5. When you fast forward to October 2022, when the Court of Appeal discharged Mazi Nnamdi Kanu, there was also a judgment issuing from the Federal High Court sitting in Umuahia, which had declared his rendition from Kenya as unconstitutional. It didn't stop there. It went as far as declaring his continued detention in Abuja as unconstitutional. What will you do or expect a responsible government to do when the detention of her citizen is declared unconstitutional? You open the gates of the detention center and allow the citizen the free pass to go home. That's what Mazi Nnamdi Kanu deserved to have been done with him since October 2022 when that judgment came. But the federal government never did. That's part of the reason why we are saying his detention has turned extrajudicial and is no longer backed by any coroner. 6, regarding the December 2023 judgment of the Supreme Court, which people are touting as having sent Mazi Nnamdi Kanu's case back to the High Court for trial, it doesn't end there. If it ends there, then it's a mischievous conclusion. The court went further. It said Mazi Nnamdi Kanu needs to go back to the High Court for trial, but it also said the High Court should not have revoked his bail. It also said that by revoking his bail, the impartiality of the High Court judge had become suspect. Ladies and gentlemen, you may not be lawyers, but when the apex court of the land tells a High Court, you should not have done this, what remains is for a High Court to do that which, or undo that wrong which he had done. And Section 287 of Nigerian Constitution backs this up, because under that section, all subordinate courts in the country, or all courts in the country, are subordinate to the decisions of the Supreme Court. It never happened. 7. Now, talking about the much vaunted trial of Mazi Nnamdi Kanu, we raised objections to this trial too, based on the conditions of his detention, which were very stringent and highly prejudicial to his right to fair trial. This application was summarily denied, and an accelerated trial was ordered in its place. We raised a second objection based on certain constitutional infirmities and statutory issues we noticed in the charges facing against Mazi Nnamdi Kanu. This too was summarily denied. So if you were Mazi Nnamdi Kanu, what will you do under the circumstances? To succumb to a trial you knew in your heart to be going towards the trajectory of an unfair trial, or to seek alternatives to that. 8. Having considered those factors which we enunciated, Mazi Nnamdi Kanu felt that the only fair way out of this logjam is to seek that his case be handled by another judge. Hence, the recusal, the famous recusal that is still roiling the system. And in concluding this press statement, ladies and gentlemen of the media, we must go on record to say this. As lawyers, our duty is to ensure that Mazi Nnamdi Kanu's case is conducted or handled in accordance with all the laws pertinent to it, particularly the Constitution of the Federal Government of the Federal Republic of Nigeria, which is the ground norm. In our view, this has not been the case, and the evidence is legion, as all who have dispassionately followed the trajectories of this case would agree. On this score, ladies and gentlemen, we make bold to state that this case has turned from the legal and the judicial to the political. This is perhaps the reason why there is a broad spectrum of persons and organizations calling for a resolution of this case outside of the judicial part, also known as political solution by baptism. These calls range from the international to the domestic, including members of the Senate, House of Representatives, the clergy, CSOs, eminent lawyers, and many others too numerous to mention. Be that as it may, and judging from 2015 when this case began, 9 years ago, there is a trove of evidence that suggests